Amid what is now a full-blown constitutional crisis, all eyes will be on the Supreme Court next week, when the country's top judges will decide whether Scotland's Court of Sessions was correct in ruling that the Prime Minister acted in an improper and unlawful way in suspending Parliament for 5 weeks. Opposition MPs leapt on the ruling, saying that Parliament should be recalled immediately. Former Attorney General and Tory rebel Dominic Grieve said that if Boris Johnson has misled the Queen over the reasons for prorogation, then he should resign. Our Scotland correspondent Kieran Jenkins has this.
Crisis no longer does it justice. 3 senior judges at Scotland's highest civil court ruled the Prime Minister illegally suspended Parliament.
The advice given by the government to Her Majesty the Queen to prorogue Parliament from 9th September to 14th October was unlawful, and that therefore the prorogation itself is unlawful.
Never before, surely, has a sitting Prime Minister been so stingingly rebuked in court. It is an explosive outcome. The judges concluded that when Boris Johnson, the Prime Minister, went to see the Queen to request that Parliament be prorogued, the advice he gave her was unlawful. And therefore, they say, the prorogation that followed is effectively voided now. It's null, they say, and has no effect. Victory for more than 70 cross-party MPs and peers. The judges ruled Boris Johnson's real intention in suspending Parliament, which sparked chaos in the Commons overnight on Monday, was to avoid scrutiny ahead of Brexit.
I think what this victory shows is that the British government cannot act above the law. Boris Johnson, in the same way that I can't act above the law, Boris Johnson can't act above the law. And much as Boris Johnson might want to thumb his nose at the rule of law still runs in Scotland at least.
Downing Street said it was disappointed, sticking with the explanation dismissed by the court, uttered once again by Boris Johnson yesterday.
So there's a massive agenda. We need a Queen's speech. That's why Parliament is in recess now, because you always have a recess before a Queen's speech. And anybody who says it's all this stuff about it being anti-democratic, I mean, donnez-moi un break.
A break is exactly what some MPs don't want. A few took their seats in an empty chamber after the ruling.
OK, so we're here today as a cross-party group of MPs.
Opposition MPs coming together in Westminster demanding Parliament be recalled.
We've gone in, we've seen that Parliament is not sitting. It should be sitting to hold this government to account.
A demand echoed by the Labour leader.
We will continue to press for Parliament to be recalled so that we can question the Prime Minister onto why he seems still unable to give an undertaking that he will abide by the European law that we passed last week, requiring him to seek an extension, if necessary, to prevent a no-deal crash-out.
It does strike me that if Parliament is recalled, then all we're going to get is another few weeks of the antics that we saw on Monday night. That was a shame for Parliament, and it shamed our democracy.
There was even a point today where the Lord Chancellor, the cabinet member responsible for the independence of our courts, had to intervene to confirm his confidence in the impartiality of judges. That was after Number 10 sources were quoted wondering why this case was heard here in Scotland and accusing the judges of being politically biased. Well, there was a furious backlash, and Number 10, disavowing those remarks, then confirmed that, yes, the Prime Minister does have total confidence in the independence of the judiciary. Are Scottish judges politically biased?
Nobody who is serious thinks that Scottish judges are politically biased in any way. To cast aspersions on the independence of the judiciary generally, but also give the impression that somehow in particular Scottish judges are politically motivated and politically biased, it's outrageous.
What do you say to Boris Johnson right now?
Recall Parliament.
Parliament is accordingly prorogued.
The government is instead appealing and may take heart today, as the High Court explained why it rejected a similar legal challenge last week. It found proroguing Parliament is a political matter. So now it's for the Supreme Court to have the definitive say next week, a hearing of thunderous consequence.
Well, now we're joined here in Downing Street by our political editor, Gary Gibbon. Gary, how did the Scottish decision go down behind the black door?
Well, one individual, not unacquainted with that building, maybe a bit adrenaline-fueled, gave a quotation to a newspaper earlier that the legal activists chose the Scottish courts for a reason. Well, that whipped around the legal establishment like a bushfire of concern, because it sounded like they were impugning the independence of the judges who made this decision. It ended up with Number 10 and the Justice Secretary putting out statements that the government supports the independence of the judiciary. It's come to something. You know, you're in a sticky place when you're having to actually proclaim that. And I think in legal circles, there's a lot of concern that we could have echoes of what happened over the Article 50 proceedings at the Supreme Court, when some judges were pretty much vilified by sections of the press and the government didn't really stand up for them. Will the Supreme Court, when it comes to the ultimate court that decides, the ultimate UK court that decides whether the Scottish court was right, will it back their judgment? If it does, then Parliament will be back. There'll be Prime Minister's questions, not the People's question time the Prime Minister was looking at on a mute iPad, but something a little bit more challenging than he did a couple of hours ago. There'll be questions potentially from select committees. There could be much more pressing harrying of the government on this whole question of how they want to see the texts and the emails, private and public, of the staff in there who've had anything to do with Brexit, anything to do with prorogation. They could think of other ways of harrying the government, but those people who know their way round the Supreme Court, who followed it, who look at the High Court judgment that came out today, think it probably, though we can't be sure of anything in this climate, probably won't back the Scottish courts. But you may need to reach for your superlatives again quite soon in terms of constitutional crisis, because all of this could be replayed, magnified, if the Prime Minister ends up with no deal and won't sign the letter that an Act of Parliament now requires him to, requesting a delay to the Brexit date. We know that there is quite a high embarrassment threshold in here when it comes to breaking convention. There have been meetings in there that have discussed the whole idea of withholding royal assent from that very bill that MPs passed, requiring the Prime Minister to ask for a delay. I understand that there were even meetings amongst the team at some point that discussed the idea of a prorogation later than the one we're going through now, potentially around the date of Brexit itself. So we know there is a readiness in there to do the unthinkable, and that adds to the tensions around this legal judgment today.
Gary Gibbon, and he'll be joining us again later in the programme. Matt.
Thanks very much, John. Well, a short time ago, I spoke to the former Supreme Court Judge, Lord Sumption, via Skype from France, and I asked him whether we are now facing a constitutional crisis.
Well, yes, we are, because the government is using the prerogative powers of the Crown in circumstances where it doesn't have a majority in the House of Commons. And since the whole basis on which ministers are entitled to use the powers of the Crown is that they do command a majority of the House of Commons, that's a fairly serious situation, as well as a very unusual one.
And is it your impression that Downing Street is saying to the courts, to the Supreme Court, bring it on, bring this fight on? Because they are fighting a campaign in which they're quite happy to pit Parliament against the people, and one suspects Parliament against the judiciary.
It's undoubtedly part of their pitch that it's the people against Parliament. We haven't yet got to the people against the courts. Maybe we'll get there one day.
Well, you did get there one day, because we had a headline in the Daily Mail last year or earlier this year saying enemies of the people. This was after it was decided by the courts that, that Article 50 should be heard in the Houses of Parliament.
Yes, we've been there before. It wasn't the press's finest hour. We may go there again. I hope not.
I guess the danger is that you have the will of the people expressed through the referendum versus the will of the people expressed through Parliament. And the collision of these two wills is the story of the last 3 years.
Yes, I think there's a lot to be said for that view. But the fact is that our entire system depends on ministers being responsible to Parliament and not directly to the people. If ministers are entitled to exercise the enormous powers of the Crown without being responsible to Parliament, they're effectively responsible to nobody, because they can't ask the people every 10 minutes, do you approve of what we're about? So that if one's going to have government by referendum, one would need totally to change our system, and we haven't done that yet.
How extraordinary is it that the Justice Minister of this administration, Robert Buckland, has to remind the Prime Minister to obey the law?
Well, that is one of his functions. Some Prime Ministers need reminding.
Lord Sumption, thank you very much indeed.
Lord Sumption speaking to Matt Fry earlier. Well, now we're joined from Edinburgh by the SNP MP Joanna Cherry, who, as we've already seen, was at the forefront of the Scottish legal challenge. Joanna Cherry, two countries, two legal systems, two courts of the same standing roughly,
Yep.
and they come to diametrically opposite views. What are we to make of that?
Well, actually, the Scottish court was of a higher standing because that's Scotland's highest court of appeal. The hearing in England was, as I understand it, at first instance. But we are in uncharted territory, and clearly there's room for a difference of opinion here. The judge at first instance in Scotland found against us, but 3 judges in the appeal court in Scotland have unanimously overturned his decision and given very detailed reasons for so doing.
But for any politician in Scotland, surely this also has a bit of a worrying underbelly, in that you could have a situation in which judges now start probing all sorts of decisions that are made by you in Parliament.
Well, judges don't unilaterally probe decisions. They only probe decisions when litigants bring cases before them with probable cause. Now, there could be nothing more important than the question of whether in a democracy it's appropriate for the executive to suspend Parliament, to prevent Parliament interfering with what the government's up to. And as Jonathan Sumption has just said, it's Parliament that holds the government to account. When Parliament's not sitting, the government can't be held to account. Now, if the Scottish judges are wrong, then it is the position that in the British Constitution it is acceptable for the British Prime Minister to suspend Parliament for any reason and indefinitely if he doesn't like what it's getting up to. Now, that cannot be right in a democracy and smacks more of what would happen in a dictatorship. So that's why I think the Scottish judges have got it right, and I would be cautiously optimistic that the Supreme Court, the majority of the Supreme Court, the UK Supreme Court at least, will follow the lead of the Scottish Court.
I suggested earlier in the programme that we're in the midst of a major constitutional crisis. Can you think of any time since the Second World War when we have faced a constitutional crisis of this scale?
No, I can't. Of course, back in almost 5 years ago, in 2014, we faced Scotland, the potential that Scotland would vote to leave the Union. But of course, that was a constitutional referendum, and the British government was pledged to accept the outcome of that referendum. So although the United Kingdom was under threat at that stage, it was under threat through an agreed process. Now it's under threat from a Prime Minister who cannot command a majority in Parliament and so has shut Parliament down to avoid Parliament scrutiny. As I said earlier, that's what normally happens in fascist dictatorships, not in democracies.
But these are desperate times if politicians have to resort to judges to try to sort out their disputes. Do you not feel uneasy about not being able to make a decision as a politician?
No, I don't. No, I don't, because I've been prevented from making a decision as a politician because Parliament's been suspended. I'm powerless as a politician to scrutinise the British government through parliamentary means at the moment because it's been suspended. And it's important for viewers to remember that it's not just the House of Commons chamber that's been suspended, it's all the work of scrutiny that goes on in the select committees, which is often far more powerful than what happens on the floor of the House. And if you look at it, the huge weight of evidence heard by select committees over the last 3 years is that Brexit is damaging to the British economy and that a no-deal Brexit would be particularly damaging. Boris Johnson doesn't like that evidence, so he's trying to prevent Parliament from hearing it and commenting upon it.
Joanna Cherry, thank you very much indeed for joining us.